Live from Atlanta, it is Tuesday, August 15th. I'm Linda Kincaid, in for Richard Quest, and this is Quest Means Business. Good evening. Tonight, Donald Trump is lashing out as he faces a fourth criminal indictment, this one in the U.S. state of Georgia. A grand jury here accuses the former president and 18 others of conspiring to overturn the 2020 election results. His former attorney, Rudy Giuliani, and Mark Meadows, the former White House chief of staff, are among the co-defendants. All of them have been required to surrender to Georgia authorities by Friday, August 25th, no later than noon. Marshall Cohen is in Washington following the developments for us and joins us live. Marshall, good to have you with us. So this is the fourth indictment after a 2-year investigation, and it's not just Trump facing charges here, but his allies, including his chief of staff, his legal team, and some Republican officials here in Georgia. Could this case be the most consequential for Trump so far?
It might be. It's definitely the most sweeping case brought against the former president. As you mentioned, it is reaching the upper echelon of the Trump White House, his former chief of staff, Mark Meadows, some of his most trusted attorneys and longtime advisors like Rudy Giuliani and others, members of the campaign. But it's so much bigger than the Trump White House and the Trump campaign. This indictment alleges several different elements of a multi-pronged scheme to overturn the election. There was the phone calls that Donald Trump placed to top officials in Georgia trying to twist their arms to flip the votes. There was the fake electors plot to try to subvert the Electoral College. The indictment also alleges intimidation of election workers, trying to persuade them to falsely admit that they had committed fraud, and even a breach of an election voting system in a rural county in Georgia by Trump supporters who were trying to prove the fraud. Linda, it all ties back to the big lie from 2020 that the election here was stolen. It was not. And the attempt by Trump and these 18 other defendants to overturn that defeat. That is the basis of this landmark indictment in Fulton County in Atlanta.
And Marshall, one of the most serious charges in this indictment is, of course, the racketeering charge, which comes with a 5-year mandatory minimum if convicted. What are the next steps? What happens next? Because I understand the prosecutors want to push things along.
They do. The district attorney, Fani Willis, gave a press conference last night, right around midnight, really milking the clock here of this incredibly long day with the grand jury hearing testimony and then casting votes and then finally unsealing the indictment. District Attorney Fani Willis, she said she wants to have this thing go to trial within the next 6 months. That's incredibly ambitious, Linda. I am certain that many of the defendants are going to be lodging a ton of legal challenges between now and then. She also said, in response to a question from our colleague Sarah Murray, that she wants to try all 19 defendants together as co-defendants. That means former President Trump at the defendant table with these other 18 individuals. Surely they will try to fight that, prevent that, because it could make their legal defenses complicated. She's going full speed ahead, the DA. Of course, it's going to be up to a judge to set this timing, set the schedule. And Linda, this is just one of 4 potential criminal trials that Donald Trump might be facing while he's campaigning for the 2024 presidential race. 4
trials, over 90 charges. Marshall Cohen, thanks so much for joining us. And these charges, of course, for Trump are for violating the state's racketeering laws, as we were just discussing. And this law is commonly used to prosecute people accused of associating with gangs or organized crime. It claims that the president's efforts were part of a broad illegal conspiracy and accuses him and his allies of harassing election workers, creating fake documents, and much more. CNN legal analyst Joey Jackson joins us with more. Joey, good to see you. There is
Thank you, Linda.
So many questions, so little time, but I want to start with that racketeering charge first, because this seems unusual. This is typically a charge used to convict drug cartels, mobsters, right?
So it absolutely is, Linda. Good to be with you. And so the reality is that you have the prosecutor using it here, and it may be, when we look at a charge like this, yes, it's for mobsters, but essentially that's what she's saying, the prosecutor, that you ran a criminal enterprise. And in that criminal enterprise, it was very far-ranging, very broad. You had a number of people who were carrying out the conspiracy. What is a conspiracy? It's when two or more minds meet and they engage in steps to have crimes committed. And what were those crimes? A crime, the core, was to really overturn this election. And so this was a very broad-ranging type of program that they were following in order to supplement electors. Georgia has 16 electors, long story, electoral college, et cetera. But the reality is that they were supplanting real with fake, attempting to do that. They were looking at people who were really having an oath of office, public officials, state legislatures, and trying to get them to avoid that. Of course, looking to the Vice President of the United States to do that, trying to intimidate election workers, breaking into a computer system, software, as it relates to votes. And so a number of things that should not have been done. The electoral process is pretty sacrosanct, right? I mean, you have to respect it. What this indictment alleges is that Mr. Trump and these 18 others did not respect that process. And it goes through, Linda, chapter and verse with regard to the activities they engaged in, as we look at them there, to circumvent the electoral process. So it's a significant development, and quite frankly, I think it's something that the president and those that we see there need to be very concerned about, particularly because of the consequences associated with a conviction.
And Joey, in this case, the Fulton County District Attorney here in Georgia wants to try all these defendants at the same time, starting in about 6 months. Is that likely to happen?
So it's not likely for the following reasons, right? We never know anything with certainty, but what happens is when you have 18 defendants, the general experience is that of that 18, they get pared down very readily. Well, how does that happen? The first way it happens is that there are people where the evidence is so compelling, and this is just an indictment. An indictment in the United States is an accusation. It's an accusation that suggests that there's probable cause to believe that you engaged in criminality, right? The targets of the investigation did. It's not proof beyond any reasonable doubt, et cetera. Far different. However, having said that, what happens is sometimes the evidence, as we look at all the charges Mr. Trump is facing, are so compelling that of the 18, you may have those who take pleas, right? That means a plea bargain, I plead guilty, you got me, nothing to see here, and I'm doing it now because I want some leniency. Then you have another pairing who want to take pleas. Maybe the prosecutor will not allow them unless they turn state's evidence, meaning you're going to cooperate. That pares it down further. Then you have defense lawyers who make what's called, Linda, a motion to sever. That means I want my client separated from everybody else because he deserves a fair trial. And if he's lumped in with everyone else, the reality is birds of a feather will flock together, jury will get the wrong impression, he'll get convicted. So there'll be a lot of motions made to pare it down. From the practical realities, it'll be pared down. And in a 6-month process, that's very aggressive, it's very ambitious. Never say never, but I don't know the likelihood and practicality of that actually occurring.
Is there any sort of practical way we would see a plea deal involving Donald Trump where he vows not to run for public office?
You know, it's a great question, and I think it's something that him and his team need to look at very seriously. I think those around him and those who know him would suggest that he doesn't plead to anything. He fights to the bitter end. He fights, fire with fire, no way, no retreat, no surrender. But I'll tell you why that is a very serious consideration, and if a lawyer sat down with them, he may fire them for making the recommendation, but let me tell you why it's valuable. When you look at the federal indictments, in the event the president got elected, Linda, he might be able to pardon himself. It's an open question as to whether the president has that authority. However, right, it's a broad-ranging authority, the pardon power, and so the president could pardon himself. That gets through now those 2 federal cases. From the state perspective, you have the Manhattan case, and now you have the Georgia case. Far different. You cannot pardon yourself, right, on a state charge if you're president, and Georgia has very strict pardon rules that it's not even decided by the Republican governor. Why is all of that relevant? It's relevant because if you get convicted because of the consequences, you face the 5-year mandatory minimum. That means no discretion. The judge, they may love you, they can't. The legislature has said you get convicted, you're doing 5 years in jail, minimum up to 20. And so you have to think long and hard as to whether or not you should take that deal and move forward. I think the president's banking upon delay, 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 delay. And in the event he becomes president, this would really take a back seat. He may never be tried on this case because of the timeline. And I think that's also a calculus he's considering too as he weighs what he should do, and his legal team tries to defend it.
So, Joey, just quickly, under what circumstances would this state case in Georgia move to a federal court?
So what happens is if there are issues of federal questions, issues relating to constitutionality, issues relating to why it should be in the interest of justice taken from one court into another court, then perhaps the court will entertain it. But understand that that was tried in Manhattan, meaning that argument to move it to a federal court, it failed. Georgia, separate state, separate circumstances. But remember that you have 50 states in the United States, and each state is a sovereign. They have their own rules, their own laws. They're governed by them. And so to what extent should a state not be independent? And why would the federal government take authority and jurisdiction over something that is a violation of state law? So there may be constitutional questions and principles which implicate federal statutes, federal laws, but at its core, these are alleged federal violations of law, state violations of law. And as a result of that, Linda, the argument will be it should stay with the state of Georgia.
Absolutely. All right, Joey Jackson. We will be speaking again soon, no doubt. Good to have you with us as always. Thanks.
Looking forward. Thanks, Linda.